all, and thank you for your patience while we have, as I understand, straightened out some technical matters. We gather today for the first day of what we are calling Stage 3 review. We've long prepared for this. Are you ready to go?
Good morning, Justice Hennessy. For appearances, my name is Harley Schachter. I appear with Caitlin Lewis. We are counsel to Whitesand and Red Rock First Nations. And Whitesand and Red Rock First Nations, as you know, started this case back in about 1999. Whitesand and Red Rock First Nation are also representative plaintiffs for the 4 other Robinson Superior Treaty Beneficiary First Nations, Fort William First Nation, Michipicoten First Nation, Gull Bay First Nation, also known as KZA, and AZA as well. And I don't know if the court wished the appearances of others. All right.
I'm content to receive an appearance sheet, which I understand was being developed. Okay, thank you.
So we are ready to proceed, and what I would like to do to start is to hand up our compendium in paper form. The compendium was provided electronically yesterday, I understand, and I don't know if the court is going to be marking it as an exhibit or what's the court's preference.
I believe in the past we have marked compendiums as an exhibit, but I might be corrected. But it's
that would be my recollection, and calling it an exhibit is just fine with me.
All right. Then it will be Exhibit A, as I understand.
First point I wanted to make about Exhibit A, the compendium, is that at tab 1 of the compendium, you'll find an outline of my proposed presentation before you. And at tab 30, you will find some brief errata relating to my written submissions in my factum and in the reply factum. I don't intend to go over them. They're just there for you to look at. Where I wanted to start is with some opening comments. We stand before this court, before Your Honor, at a fork in the road on the path to reconciliation. Now, in saying this, I don't believe that I'm over-exaggerating the importance of choosing the right path. In this constitutional case, which is a case involving a review for constitutional compliance, care must be taken to ensure that the foundation of our nation's house is not eroded. Our nation's foundation is not of concrete, stone, or bricks. It is an ideal. It is the coming together of nations who have entered into understandings and solemn compacts, often in writing and in the Aboriginal context called treaties. These sacred promises must be honored if we are to live in harmony within the constitutional democracy we call Canada. In this case, before you are 2 very different visions of how treaty rights enshrined in the Constitution, are to be reconciled with the Crown's assertion of sovereignty. And there are 2 very different views of what reconciliatory justice means. In the first, advocated for by the Crowns and under the guise of Crown discretion, guaranteed constitutionally entrenched rights are diminished. The treaty right effectively is being reduced to a matter of Crown discretion. Now, neither Crown will claim that that is what they are advocating for, but that is the practical result of their vision of the rights and the duties at stake. The court must guard against this. Secondly, when it comes to remedies, and I'm talking about remedies not for asserted rights, but for proven breach of treaty rights, Ontario seeks to convert the reconciliatory justice framework so recently pronounced upon by the Supreme Court of Canada in a case called Takuhikan into what I would describe as justice light. From Ontario's perspective, Aboriginal reconciliatory justice actually affords a lesser justice than other Canadians are entitled to. Unlike other Canadians who are compensated for the loss caused by the breach of their rights, be it a charter right or a contractual right, in Ontario's view, when Aboriginal people's constitutional rights are infringed, Aboriginal people can have no similar expectation that there will be a full accounting and a full compensation for the losses that they suffered. Instead, in Ontario's vision of reconciliatory justice, Aboriginal people must be content with payment that need not take into account what they lost, but only needs to be an amount that the Crown, the very party in breach, decides is sufficiently reconciliatory in some holistic manner that the Crown decides upon, and to which they would say the court must defer to. Canada, for its part, is not nearly so clear as to what reconciliatory justice means. But like Ontario, their implementation of that ideal is actually not consistent with the principles articulated by the Supreme Court of Canada into Takuhikan. Respectfully, the Crown's debasement of Aboriginal constitutional rights, whether by effect or design, is particularly troublesome in this case. Ontario's articulation of the content of reconciliatory justice and Canada's implementation in respect of same are grievous errors. They are errors sufficient in and of themselves to render the decisions unsustainable. I want to remind the court that before the Supreme Court of Canada, and as Justice Jamal remarked on in the Restool decision at paragraph 13, Ontario counsel in the Supreme Court of Canada, and notwithstanding the admitted 150-year breach, requested that the court prevent the Superior Court, this court, from proceeding to its own determination of what the past compensation should be. Ontario's counsel responded and assured the Supreme Court of Canada, "We are listening, and you are going to tell us what to do." Now, within the 6-month engagement process that followed, the Crowns have shown themselves to be listeners. However, they may have listened, but to the plaintiffs, it does not appear they truly heard much of what the Anishinaabe were saying. And of what the Anishinaabe were saying, and even that which they heard, much less was taken to heart. There continues to be a great divide among partners to Confederation, partners who are supposed to be equals at the council fire. There is a great divide remaining. In the result, if the court agrees at the end of the day in this proceedings that constitutional compliance has not been shown in respect of the manner in which the Crown approached the engagement process, or in respect of the Crown's decision as to how past compensation should be quantified, the court should be wary about remitting matters back to the Crown for reconsideration. The other part of my opening remarks that I want to deal with is I want to remind the court of the overarching approach that we take to this proceedings. Is that the Crown's decisions are unsustainable under any standard of review. My opening comments in stage 3 at the trial expressed concerns over letting the Crowns have the final say in how to best implement the treaty promise. And I also spoke about the importance of substantive equality. Now, thankfully, the Supreme Court of Canada has firmly held that the Crown does not have the final say, but the court does. And that the issue to be decided is not a judicial review of an independent administrative tribunal who is due deference in respect of the core of the matter to be decided. And what is to be decided is whether the engagement session and the quantification of past compensation are constitutionally compliant. We will see from the law that it is for the court, the guardians of the Constitution, to ensure constitutional compliance. At the end of the day, neither Crown's determination of past compensation is sustainable under any standard. It matters not what the standard is. What matters is constitutional compliance. Now, I propose to show you significant errors in a reasoning path, errors in law that render both the process and the result unsustainable. Generally, it is an error of law to misconceive the seriousness of the claim or the impact of an infringement. That's a legal issue. It is an error of law to base one's decision on a misunderstanding or mischaracterization of the scope of the right that is to be vindicated. It's an error of law to base one's decision on a misunderstanding of what the law requires of them. It's also an error of law for a decision maker to fail to meaningfully consider all the relevant facts that they should have considered. Not just the facts that they chose to consider, but the relevant facts that should have been before them. And of course, it is an error of law for a decision maker to consider facts that are irrelevant. We say that the Crowns committed all of these errors. Moreover, even absent errors of law, the result of the Crown's approach does not fall within a range of outcomes that are consistent with the facts and law that constrain any legitimate discretion that the Crowns do possess. Neither the engagement sessions nor the result are consistent with the core of the treaty promise or the honor of the Crown. The result is far from the conception of reconciliatory justice that the law requires. I might say that in their zeal to win the day before the Supreme Court of Canada, it was the Crowns who praised the appropriateness of a $10 billion amount and who decided and derided that who expressed the concern over the prospect of having to pay $126 billion. What I don't recall the Crown saying before the Supreme Court of Canada was that the RST, the Robinson Superior Anishinaabe, owed the Crown $4 billion that had to be worked off over the next 300 years before there might be any monies due. Now, you might remember from reading the Supreme Court of Canada decision, the Supreme Court of Canada talked about the Crowns not being able to complain about sticker shock. Well, let's keep perspective on that. The sticker shock that the Supreme Court of Canada adverted to, and which the Crowns themselves adverted to, and which the Crowns have no right to complain about now, was a range of their own making, from 10 billion to 126 billion. That is the range that they were telling the Supreme Court of Canada was important. Now, with that concludes my opening comments, and I would proceed to brief comments on standard of review and onus. That's item 2 of my outline. I don't want to spend, and I don't propose to spend too much time initially. I might need to in reply, we'll see. But initially, I don't think I need to spend too much time on either onus or on standard of review. I want to start by saying that the Supreme Court of Canada in the decision said at paragraph 290 that it is for the Crown to explain how it reached its determination at why and why. At paragraph 308, the Supreme Court of Canada said this court must focus on the justification of the Crown's determination. Now, the how and why is only within the knowledge of the Crowns. Whether one calls it a legal onus, an evidentiary burden, a practical onus, or a legal onus, or a persuasive onus, or a persuasive burden, I don't think it really matters, because it is evidence about the how and the why is evidence that only they actually have, and it is their actions and decisions that are to be justified. Turning to the standard of review, I remind the court yet again, I'm sure it's probably said a dozen times in my factum, that this is not a judicial review of administrative action. It is a review of the executive for constitutional compliance. And there's three cases I really wanted to focus in on, because I really believe that those three cases help understand and put in perspective why deference is not warranted and why a correctness standard should apply. And the first case I want,
Before you go further, Mr. Schachter, do you say, and you have made this distinction throughout your filings, throughout your factum, it is not a review of administrative action, it is a review of the executive for constitutional compliance.
Yes.
And would you point to where you say the Supreme Court recognizes that distinction? And is it in their words, honorable, liberal, and just? Where is it that you say they set that out?
Well, I don't think they set it out precisely. I don't think you will find in their decision that the standard of review for constitutional compliance will be correctness. They don't go that far.
Well, that's not my question.
But if you read their decision, and I don't have an answer for you immediately on this. So
okay. But I'll just make sure you understand the question. I know that the Supreme Court does not speak to standard of review, but where do you say, if you say that the Supreme Court characterizes what the Crown is doing is executive action that must meet constitutional standards.
Okay,
And you can come back to that.
I will come back to that probably after the break. But thank you for the question. I don't have an immediate answer for you. I want to just collate the sections where I can help you with that.
Thank you.
But in terms of trying to understand the broad picture, I want to first turn to a case from the Supreme Court of Canada called Multani. Multani is a 2000, you'll find it tab 3 of my compendium. Now, Multani is a case from 2006, and it predates the change of the law in Vavilov. It predates Vavilov. But what it says about standard of review resonates when you try to understand the difference between judicial review of administrative action and review for constitutional compliance. And the Supreme Court of Canada in 2000, and I might say that we've come sort of full circle with York Region to recognize that correctness is the appropriate standard. But let me stick with Multani for now. Now, Justice Charron, speaking for the majority, says, and I'm going firstly to paragraph 15. And I might just add for the court's convenience, at the bottom right-hand side, there are numbers in red on the hard copy of the compendium. Those numbers are numbers of the page numbers of the compendium.
Thank you very much.
And in case anyone ever gets lost, that's an easy way to find our way back. So at page 21 of the compendium, paragraph 15, under the heading preliminary issues, Justice Charron for the majority writes, although the appropriate standard of review in the case at bar was not argued at trial, it was in the Court of Appeal. Then in the middle of the page, having found that the decision infringed Gurbaj Singh's freedom of religion and conscience, the Court of Appeal then incorporated the administrative law standard of review into its analysis of constitutional justification under Section 1 of the Charter. My colleagues, Deschamps and Abella, see no reason to depart from the administrative law approach adopted by the Court of Appeal at paragraph 95 he refers to. They also believe that it is both sufficient and more appropriate in the case at bar to rely solely on the principles of administrative law to decide the substantive issue rather than applying the principles of constitutional justification. Justice Charron goes on, with respect for the opinion of Deschamps and Abella, I am of the view that this approach could well reduce the fundamental rights and freedoms guaranteed by the Canadian Charter to mere administrative law principles, or at the very least, cause confusion between the two. It is not surprising that the values underlying the rights and guarantees of the Charter form part, and sometimes even integral part of the laws that we are subject. However, the fact that an issue relating to constitutional rights is raised in an administrative context does not mean that the constitutional law standards must be dissolved into administrative law standards. The rights and freedoms guaranteed by the Canadian Charter establish a minimal constitutional protection that must be taken into account by the legislature and by every person or body subject to the Canadian Charter. The role of constitutional law is therefore to define the scope and protection of those rights and freedoms. An infringement is only justified if it meets the requirements of Section 1, and then they quote from other Supreme Court of Canada cases. And at paragraph 18 over on the next page, as stated above, it is compliance of the commissioner's decision with the requirements of the charter that is central to the appeal, not the decision's validity from a point of view of administrative law. Now, at paragraph 21, page 23 of the compendium, Justice Sharon concludes, thus, it is the constitutionality of the decision that is the issue in the appeal, which means that a constitutional analysis must be conducted. Deschamps and Abella actually had a different view, and the reasons why they had a different view are what's telling. Not because I'm saying that Moltani's analysis of administrative law remains the same. I mean, we do have Valve to contend with, but the analysis and the reasoning of the minority provides a window and an understanding why Justice Rowe eventually returns to correctness for constitutional questions, and why a correctness standard for the executive makes all the more sense. The minority at paragraph 121 in dissent say an administrative decision maker should not have to justify its decision, which is based on an analysis of societal interests and is better suited conceptually and literally to concept of prescribed by law. The test is based on the duty of the executive and legislative branches of government to account to the courts for any rules that they establish that infringe protected rights. The Oakes test was developed to assess legislative policies. The duty to account imposed, conceptually and in practice, on the legislative and executive branch is not easily applied to administrative tribunals. Paragraph 122, and here's the crux of the matter. In commenting on the application of the Charter to common law, McIntyre, writing for the majority in Dolphin Delivery, wrote the following. The courts, of course, bound by the Charter as they are bound by all law. The courts are, of course, bound by the Charter as they are bound by all law. It is their duty to apply the law, but in doing so, they act as neutral arbiters, not as contending parties involved in a dispute. And the point that the minority make is the same reasoning applies in the context of administrative law. Like the courts, administrative tribunals are bound by the Canadian Charter. They're enabling legislation and the statutes they are specifically, enabling legislation and the statutes they are specifically responsible for applying. And here it is. Like the courts, they cannot be treated as parties with an interest in a dispute. A tribunal's decision should not be subject to the justification as if it were a party to the dispute. And here is the theoretical difference. When you're reviewing for constitutional compliance of the executive, and the executive is a party to the dispute, they are not acting as an independent arbitral body whose who we would say can be who we can say have any expertise in the particular matter of either fact or law in which they are opining, so to speak. And it is actually not their role. This is the wheelhouse of the court, facts and law. And it is the wheelhouse of the court, and we'll get to what the Supreme Court of Canada in Restool says about it later. It's for the courts as the guardians of the Constitution to protect those rights and to choose specific remedies for those rights. Turning then to McKinnon. This is at tab 4. McKinnon is the recent 2025 federal court case that dealt with the proroguing of Parliament by then Prime Minister Trudeau, or sorry, the request by Prime Minister Trudeau of the Governor General to prorogue Parliament. And in that case, the argument was that this exercise of prerogative power could be challenged. The question was justiciability. Could it be challenged? If it could be challenged, how should it be challenged? There were some, as we will see, there was some discussion. Now, the reason why the case is important is it has a good discussion of why it really doesn't matter what the standard of review is when you're looking at whether or not whether or not the executive or the prime minister when they're exercising a prerogative power, whether or not it's correctness or reasonableness, because it's a binary question of is there constitutional compliance. So you'll find at I think I can jump probably to paragraph 105. More recently, the Supreme Court of Canada has assessed the exercise of Crown prerogatives through a broader constitutional and rule of law lens. And towards the end of paragraph 105, the Supreme Court of Canada added that it is for the courts to determine the legal and constitutional limits within which decisions to exercise Crown prerogative powers are to be taken, referring to Cotter. They then go on to say that the matter is justiciable, or the judge Crompton goes on to say that the matter is justiciable, and when he turns to standard of review, you'll find that at page 29 of the compendium, paragraphs 148 and following. He first quotes from Vavilov. The Supreme Court of Canada established standard of correctness applies when reviewing questions regarding the relationship between the three branches of government. And then paragraph 149, I accept that the foregoing teachings of the Supreme Court of Canada appear to suggest that this court should adopt the correctness standard of review in assessing whether the Prime Minister exceeded his authority in making the decision. 150. I am also inclined to consider that there's a second reason why such an approach, the correctness approach, should be adopted. This is that the constitutional and other legal limits of the Crown's power to prorogue Parliament is a question of central importance to the legal system as a whole. He then goes on to observe at paragraph 151 something very important. Despite the foregoing, the jurisprudence does not appear to provide much guidance regarding the standard of review to apply when reviewing specific exercises of the Crown's prerogative powers that have been challenged on the ground of being ultra vires the authority of the relevant executive branch actor. Indeed, Several of the cases that found a challenged exercise of Crown prerogative to be justiciable did not address the standard of review. Again, one of the important cases they refer to is Cotter. Crompton makes the point that in Terp versus Canada, a correctness standard was applied. And then at paragraph 152, the respondent submits that this paucity of relevant jurisprudence, it's explained by the fact that the question of whether a particular exercise of prerogative power exceeds its scope is not one that lends itself well to a Vavilov-style analysis. The applicants contend that the determination of whether the Prime Minister did or did not act within the scope of his authority is a binary question. In this regard, they note that in Huppeskath, Justice Stratus of the Federal Court of Appeal stated that he did not need to consider whether the standard of review of the decision that was before him was correctness or reasonableness. This was because if the standard was reasonableness, the only acceptable and defensible outcome available to the Government of Canada in this case is compliance with the law. Referring to Huppeskath at paragraph 73. And in this federal court decision, the judge concludes, I'm inclined to consider that this reasoning also applies to the decision under review in these proceedings. Now, that's where we are in this case. We're at the stage where it doesn't matter whether it's reasonableness. What matters is compliance with the constitutional rights. What matters is a correct understanding of what the rights are and a correct response to those rights that are so central to our democracy. They fit, in any event, within the Vavilov exemptions. And in York Region, which is at tab 5, the Supreme Court of Canada in 2024, according to the minority, changes the law. I'm not sure that they do. I think it's probably just a reaffirmation of the need for a correctness standard in constitutional questions. But in that case, Justice Rowe, for the majority, when he talks about standard of review, and this is at page 32 of the compendium, paragraph 62, starts off by saying the correctness standard applies to the determination of whether the charter applies to school boards. Then at paragraph 63, the correctness standard also applies to review of the arbitrator's decision, plain and simple. He goes on to point out at 64, the determination of constitutionality, which is what we're involved with in this case, calls on the court to exercise its unique role as interpreter and guardian of the Constitution. Courts must provide the last word on the issue because the delimitation of the scope of constitutional guarantees that Canadians enjoy cannot vary depending on how the state has chosen to delegate and wield its powers. That statement applies to this case. He makes the point that Vavilov does not restrict the scope of constitutional questions to only issues of federalism and the constitutional delegation of state powers. Notably, he says, this is in the middle of 165, Vavilov uses non-exhaustive language articulating the constitutional questions category, including within it other constitutional matters, and the other is an emphasis in York Region, not mine. The category should not be unduly narrowed. Now, he returns and repeats Vavilov at paragraph 70 over on page 33. And he underlines the application, and I'm reading from the middle of the paragraph from Vavilov, the application of the correctness standards for such questions, and that's the questions that require a correctness standard, which constitutional questions, general questions of law of central importance to the legal system as a whole, and questions regarding jurisdictional boundaries between two or more administrative bodies. The application of the correctness standard for such questions renders the unique role of the judiciary in interpreting the Constitution and ensures that courts are able to provide the last word on questions for which the rule of law requires consistency and for which a final and determinative answer is necessary. And eventually says correctness for everything, even within an administrative tribunal, an independent, impartial tribunal at that, one not having a specific stake like the Crown in this case has a stake. Justice Karakatsanis and Martin had a little bit of a different view. And this is at page 34 of the compendium, para 108. We agree with the parties in Roe that the issue of whether the charter applies is one that must be correctly determined. However, they say at the end of that paragraph, we do not agree with how our colleague reviews the decision. And their theory or their view, which is the minority and which was not accepted, was that there's no basis to depart from the presumption of reasonableness. And at paragraph 125, they refer to a casino case from Quebec. We do not read the casino case as purporting to erase the important distinction this court drew in Vavilov between the constitutionality of a statute and an administrative decision's effect on charter rights. This is the same kind of distinction that the Crowns urge upon you and say, this is the Dore framework. The Dore framework saying, first you look at the, to determine whether or not there is whether there's a constitutional matter involved, and then the effect of the decision on the constitutional right itself. Now, within the sphere of administrative law of tribunals, that may or may not still be the law. It seems from York, there's now a change in the law. But even if there is a change in the law, and the minority would say, and if you look at paragraph 127, they say, nor do we accept that the court cases referred to by the majority qualify as a line of developing authority that requires a correctness review for whether a charter right arises on the facts or for questions about the scope of the charter right. Such approach introduces uncertainty on what it means for a charter right to be engaged, apply to, or arise from the facts. Roe's reasons at paragraph 63 and 69. It undercuts Vavilov's careful recalibration of the standard of review framework, which makes plain that not all questions of constitutional interpretation require a correctness review. They then say Under Vavilov's terms, questions about the engagement and scope of the charter right will only sometimes require a final determinative answer. So for the minority, even the scope of a charter right does not is not subject to a correctness standard. But even the minority said when it comes to Aboriginal rights, correctness does apply. And if you just refer back to paragraph 120 of the decision at page 35, you will see where even the minority says that when it comes to the scope of Aboriginal and treaty rights under Section 35 and other constitutional matters, they require a final determinative answer from the courts. And again, that's underlining in the original case, not by myself.
Sorry, let me find that in 120. I see it.
That's at page 35 of the compendium. In the middle of the page, paragraph 120, they're just quoting their approval of Vavilov. And so it's a little bit strange if you ask me that the minority is saying even the scope of charter rights should not be dealt with on a correctness basis. Well, they were in the minority in that. Justice Rowe has firmly placed himself in the camp of a correctness review. And even the minority expressly mentions that the standard of review for the scope of Aboriginal and treaty rights under Section 35 remains a constitutional matter. And essentially, the constitutional question before you, or the issue before you, is really a constitutional question. Is there compliance with the constitutionally entrenched treaty right, and is that consistent with the honor of the Crown, which is a constitutional matter? So if you have to make the decision, it's correctness. But my point is you don't have to make the decision about whether it's correctness or reasonableness, because under any standard of review, the result is the same. And I can see you have a question.
Thank you. When the court uses in that quote from Vavilov at paragraph 20, other constitutional matters require a final and determinative answer from the court, is that AKA correctness standard?
Yes. And all of that, quite frankly, makes very good sense, because we can't have the executive defining for itself what its rights, what the bar is. If we go down that route, I mean, if you go down the route of allowing the Crowns the ability to decide facts in this case, and to decide, interpret the law and interpret their own obligations under the treaty, you're actually giving back to the Crowns that which the Supreme Court of Canada said they don't get, unfettered discretion. You turn the treaty right into a matter of Crown discretion. And that, all levels of court said, is not what this treaty is about. It's not the way to enforce treaties in Canada in our constitutional democracy.
Isn't the question not so much into a matter of Crown discretion, but isn't the debate whether it's a constrained discretion or an unfettered discretion? The Supreme Court reminded us that the determination of annuities was a matter of some discretion, of Crown discretion.
Right. But the discretion is a discretion to choose from among, if I can put it so boldly, to choose from a range that the court decides is within the appropriate range and meets constitutionality. It's not for them to define the range. It's for the court to say whether they're in the range. And this is why it's a little bit, I think in my factum, I talk about how you can have sometimes a correctness standard you can have different outcomes still within a correctness standard. And sometimes under a reasonableness standard, there's only one right answer or one answer that satisfies the court. So whether it's reasonableness or correctness, it's got to be the right answer within a range that the court, as the ultimate arbiter of constitutional rights, is satisfied about. So yes, the discretion, there is discretion, but it's not discretion within any range that the courts think about. It's
or the Crown.
Not that the Crowns themselves, thank you, think is appropriate. It's the Crowns having to get it right that their discretion fits within the range that is constitutionally compliant. And the court sets that range, not them. And both in process and in result, we hope that our factum and our oral presentation will convince the court that they are nowhere within that range. And I do not know when the court wishes to take a break at all.
Well, I actually was going to ask you to tell me where we're going or where you are in your...
Where I am in my presentation is making good progress, and I'm at item number 3, I believe. Sorry. I'm about to move to the 3 big ticket items.
Are you saying this is a good time for a break?
Yeah, I mean, yes, because the next section is going to be, I think, a little bit long.
Okay, why don't we do that?
Okay.
15 minutes, is that enough time, I think? All right, 15 minutes, please.
This court is sit down for 15 minutes.
But if we're going to show.
This court is resumed. Please be seated.
Before the break, the court asked a question about where in the Supreme Court of Canada does decision in Restool, does the Supreme Court of Canada talk about the role for the court, if I have maybe got the question correct. And I want to start with paragraph 299. I think paragraph 299 is where I can start and probably finish, but because I think it encapsulates clearly the role for the court. The Supreme Court of Canada says, although it is not the business of the courts to force the Crown to exercise its discretion in a particular way, it is very much the business of the courts to review exercises of Crown discretion for constitutional compliance, to ensure that the Crown exercises its discretion in accordance with its treaty obligations and the constitutional principle of the honor of the Crown. It is appropriate in this case for this court to order the government to repair the breach of its constitutional obligations while leaving it up to the executive branch to determine the best means to do so. Now, it allows for discretion, but ultimately it is the role of the courts to ensure that the discretion falls within an acceptable constitutional range. That's the ultimate constitutional question. Over at paragraph 308, the court goes on to say, If the Crown has exercised its discretion liberally, justly, and honorably in determining the compensation in respect of the past breaches, then the courts should not intervene. That's a precondition. They only get discretion if the court is satisfied it has been exercised liberally, justly, and honorably. So the court doesn't defer to their discretion unless they meet the bar that the court sets. That's the point. And you'll see that this is carried forward in paragraph 310, where the Supreme Court of Canada says, however, if the court finds that the Crown's process or determination was not honorable, it may consider an appropriate remedy. I might say that this idea that the Supreme Court of Canada has about the importance of the courts having the final say resonates, at least it is the same sort of idea that I wrote about in my reply factum when I referred to an excerpt of a book by the noted jurist Aharon Barak on proportionality. And that I'm just going to quote from it because it is important, I think. In his important work, and Aharon Barak has been quoted numerous times by the Supreme Court of Canada and other jurists in Canada, well-respected constitutional scholar. And at paragraph 18 of my reply, I quote from Aharon Barak in this book that I've just holding up, where he talks about the separation of powers is not a license granted by the Constitution to each of the branches to violate the law. And then he continues, and I'm only going to quote the part in the middle of the page. According to this notion, sorry, middle of the quote, according to this notion, whenever a question arises as to the proper interpretation of the constitutionality of an action undertaken by a government branch, such a question should ultimately be resolved by the judicial branch. A constitutional democracy does not allow the legislative or the executive branches the final word as to legality or constitutionality of their own actions. Indeed, the notion of separation of powers does not grant each branch absolute power over its own domain. Rather, according to the principles of checks, it is the hallmark of the modern understanding of the separation of powers. The judiciary is the sole government branch entrusted by the Constitution with the task of having the final word as to legality, as to the legality and constitutionality of the actions taken by the other branches of government. Any other solution would seriously impede democracy. And no truer words have been said, and no better result is needed in this case than ensuring that the court, not the Crowns, have the final say on whether or not the quantification passes constitutional muster. Having advocated so heavily for correctness, I want to assure the court that our position is that it doesn't matter, that under any standard, they don't meet either a reasonableness standard or a correctness standard. Before the break, I said I was going to move to an overview of the three big ticket items. And I wanted to sort of deal with those at the outset because let's call a spade a spade. These three issues are what is keeping the parties apart. It is the three critical issues that the court is going to have to decide upon. And they are: one, the quantification of the net crown benefits. What actually were they that were historically captured by the crowns over the years? And secondly, what share of those net benefits should have been paid by way of augmented annuities in the past? And three, what is the proper bring forward rate that needs to be used? It's those three variables that make the difference between Ontario's original argument that there's negative 8 billion, then negative 4 billion, then plus 375 million, then plus 2.7 billion. It's those three issues that separate that and up to not 126, because the 126 billion actually includes not just what was captured, but what could have been captured. What the top end of what was captured is around the 70 billion mark, or I think it might be 90 billion now with the effluxion of time. The point is there's this huge gap, and the huge gap needs to have, there needs to be decisions made by this court on those issues. We say that for any decision to be constitutionally compliant, the decision must be one that firstly quantifies a realistic range of net crown benefits that were in fact captured over the years. This is effectively the stage 3 trial. What was captured? Not today, the stage 3 trial, but we've been through that evidence. Secondly, you need a decision must identify what the past augmentations retrospectively would have been in the past. This requires identifying some sort of share in the past, identifying retrospectively perhaps in what years might the Crown not have paid, what would it have done if it didn't pay, those types of considerations. And thirdly, identify what the Anishinaabe lost by not having the access to the funds that they should have had in those years past. That's the lost opportunity factor. This requires identifying an honorable, just, and generous bring forward rate. Now, Ontario simply does not engage in the exercise. This is a fundamental error on their part. They do not ask these important three questions. They approach it from the wrong perspective. Meanwhile, Canada actually does claim that it is following this analysis. And at their factum at paragraph 111, you'll find, we don't need to turn it up, but at their factum paragraph 111, they say this. They say, we are following the same analysis Mr. Schachter says is the appropriate one. The problem, while they claim to be following that analysis, they choose an approach that is both unreasonable and incorrect by any measure. In both cases, the way that each Crown gets to a result is an unsustainable result. And I want to sort of explain how I understand the difference between the parties. In a nutshell, Ontario's calculation of NCRRs, that's net Crown resource revenues, that were historically available to be shared up to 2019, even with their late concessions, has simply gone from less than 0% of what Mr. Hutchings' nominal amounts to be to 2% of what Hutchins nominal amounts to be. This is the important big picture difference on NCRRs. And I've broken that down for you, and I don't intend to turn it up right now, but for reference, it's at paragraphs 126 to 130 of my factum and appendix B of my factum. I break it down and explain how by presenting the $2.7 billion amount as an amount brought forward by bond rates already, it actually masks what's really going on. The real issue is Ontario in the ballpark when it says there's 20 million over 175 years, or is Hutchins more in the ballpark when he says there's 1.043 billion over that in nominal terms over that same 175 years in net crown benefits directly captured?
Do you get the 20 million from working backwards?
Yes.
Thank you.
Well, that's what Appendix B does. It takes the 2.7 billion, works backwards with the data, and shows that it's actually 20 billion. And so, I mean, in a nutshell, my argument is that 20 billion is not in the range. The 20 million, sorry.
I got it.
The 20 million from Ontario is not in the range. I think in our final analysis, we put the 20 billion as being the bottom end of the range. But 20 million of NCRRs is not in the range at all. Now, Ontario, of course, adds nothing for the period 2019 to 2024. Now, from their perspective, this would make sense because according to Bodway and Smart, Ontario's experts at stage 3, since 1963, there's only ever been losses. And as the stage 3 trial talked about, it could be hundreds of years before there's a positive amount. So it does make sense when Ontario doesn't add anything after 2019, but only if Bodway and Smart are correct. Only if this court agrees that Bodway and Smart are within the ballpark when they say there's never going to be anything after 1963 until things turn around. Now, while Ontario adds 25% to NCRRs to account for indirect capture, which approach, by the way, I can say in principle is acceptable for past compensation, but given their low NCRR calculation, the 25% add-on adds actually very little to the benefit in total. Now, Canada, we've put in our factum, uses a false polls analysis that relies principally on Bodway and Smart as well. And Canada arbitrarily adds 120 million for the period 2019 to 2024. So at least they attempt to provide something, but it's very minimal. And their false polls analysis by simply asserting that the bond rate is, they bake the bond rate into their polls, which is wrong. If they wanted to take a proper poll approach, they might take Ontario's 2.7 billion at bond rates, or they might take the 20 million versus the 1 billion, choose something closer to Hutchins. I mean, because if they wanted to choose closer to Hutchins analysis, they would choose closer to the 1 billion than the 20 million. But by assuming and baking in the bond rate, Canada creates false polls when they should have said, if we want to compare bond rate and Ontario's 2.7 billion of 2% of Hutchins to Hutchins, not at bond rate, but at Hutchins at 60-40 rate. Well, then you have the range. That is the true polls. The polls are not between 2.7 billion and 11 billion based on bond rate. That's assuming the bond rate is the right rate.
They create, but you say they create the polls.
They create the polls, but an honorable crown would at least acknowledge and consider, what about what about the other position? Is any other rate other than a bond rate an appropriate rate? Now, Canada is eventually going to answer that and say, no, it isn't. But their analysis is wrong about that. Their consideration of the evidence is off. That's not what happened in stage 3. And we're going to get to that eventually. But Canada, although its NCRR calculation is a false polls calculation, ignores any indirect capture, even though all experts agreed that there was indirect capture relating to lands and resources. So their failure to include in something is an error in principle. Now, I mentioned a moment ago that when it comes to the third variable, the bond rate, both crowns use the bond rate, but the bond rate is not an appropriate rate to use. The Crown, Ontario and Canada have different rationales for why the bond rate is to be used. Canada claims that the bond rate represents the Anishinaabes' lost opportunity. Respectfully, that is not supported by the evidence from stage 3. It is not supported by the evidence from the engagement process. And it is not supported in any way by any other fashion or any other documents that the Crown has produced or the minister could rely on. Ontario takes a different tact. Ontario actually denies that lost opportunity is a relevant consideration and uses the bond rate because it is the measure of the Crown's cost of performance. This is a fundamental error of law. I will get to how Southwind explains that. Now,
Cost of performance being their cost of borrowing.
yes, they basically say, look, we're not here to look at what you lost. We only have to calculate what benefits Canada, the Crown gained. And so it's all about what benefits we had, not what you could do with the benefits. Or not with what the First Nations people could do with their share of the benefits retrospectively in the past. They completely missed the point of the Supreme Court of Canada's exercise, which is you breached a treaty, you have to pay compensation for that breach, and you have to retrospectively identify what the annuities would have been. They don't engage in that at all. Now, when it comes to the share, the Crown's approach, each Crown approaches the matter differently. Ontario is prepared to pay greater than 100% of its $2.7 billion or 20 million in nominal terms of its calculations, plus 25% of indirect capture. Now, I would propose that the reason why they're in it over 100% is because the amount is so low. But I guess they can explain it for themselves. But Canada, however, arrives at a sharing of 20 to 50% share of approximately 5.5 billion to be shared. Now, there are logical errors that I'm going to discuss as the days progress in the next day or two about their sharing analysis. But it's important to understand that you've got a lot of words and a lot of purported explanation by the Crowns as to how principled and honorable they were in their determination of amounts. But all the machinations that the Crowns go through are in fact unprincipled. All that really matters in the end to them, I say with, I say, is the outcome. It's unprincipled because each of them claims that if the inputs are adjusted upwards in favor of the Anishinaabe by the court, if the court were to do that, then they would have to revisit what they are prepared to pay by way of a share, or what they in their holistic determination think is fair. It's not principled at all. And I want to refer you to the following 4 citations. Ontario decision letter, paragraph 17. I'm not going to turn them up. Ontario factum, paragraph 270. Canada decision letter, page 10. And Canada argument, paragraph 87. In those 4 citations.
Page 10 for the Canada decision.
Yes, Canada, page 10, Canada's decision doesn't have paragraph numbers, so.
Thank you.
Canada decision letter, page 10, and Canada factum argument, paragraph 87. In those 4 excerpts, one will find the ministerial and their lawyers arguing and explaining that if the inputs change, then the decision, the amount that we're prepared to share changes. What that should tell the court is that the focus is not on a principled approach to treaty implementation. It's on an ad hoc, what feels good, holistic approach, untethered to the evidence, untethered to the facts, untethered to the history, and untethered to the loss caused.
Or as you, or I thought you argued in your material, that it's tethered to a comparable per capita amount. Because I say that because you say it's what did you say? Untethered to the facts, or I thought you, what did you say? You described it in one way.
I do say that, and I'm about that's about almost the next paragraph in my presentation. And no, that's okay. That's okay. I wanted to make this point. You might recall that the Supreme Court of Canada says that there are supposed to be annuity calculations. And let's see. At paragraph 294, you can just note this. The Supreme Court of Canada talks about polycentric choices and things that are going to affect the annuity calculations. But I wanted to just focus on the fact the Supreme Court of Canada is expecting annuity calculations for the past. And the annuity calculations that the Supreme Court of Canada required for, if you actually take to heart that the inputs really don't matter if the number's not right for Canada, then really those inputs are just window dressing. It's not an honorable approach. And it tells us that all that matters is achieving the end and desired result. And this is where I come to the desired result seems to be some parity with a settlement that is irrelevant. At the end of the day, both crowns miraculously come up not only with the same result, but it is a result that is within 1% of the Huron settlement based on a per capita consideration of populations in about 2018. Interestingly, Canada, at paragraph 9 of its factum, claims that each crown came up with the exact same quantifications independently. With respect, that's just not believable. In a world where there's a range between 0 to 126 billion, it's just not believable that we would independently come up with 3.6 billion. There had to have been collaboration and discussion. Now, I'm not suggesting that collaboration and discussion among emanations of the crown is wrong. I'm not. But that collaboration and discussion, if it was going to take place, it should have included the Anishinaabe. It should not be the case that the Anishinaabe are left out in the cold when treaty partners are discussing how to deal with past compensation. What this tells us, it speaks to the mindset that the crowns have. It's a we versus they. The Anishinaabe have consistently approached this issue as an us. This is a fundamental difference in approach. For the Anishinaabe, it is a treaty relationship among equals. For the crowns, it appears to be the crowns versus the Anishinaabe. This is not what the treaty bargain was ever about. And in the final result, it truly does look like the was a preordained result that links the RST payment to a 2023 Huron settlement, of which the details the court has no way of knowing as to whether or not by any metric the $10 billion is a just, liberal, or honorable one that the Hurons came up with, or that the Hurons and the Crowns decided upon back in 2023. If you actually wanted to compare the, if for the Huron settlement to be relevant, there'd have to be full disclosure. And the issue is not, quite frankly, whether there can ever be any comparison. There can only be a comparison if it's relevant. And here's where it fails. The $10 billion amount, quite frankly, could just be a number picked out of the air. If you did want to compare, the proper question to ask is, if the Hurons would have not settled, and if the Hurons would have come to this court based on the facts as found by the Supreme Court of Canada, and the situation as it changed dramatically from 2023 to 2025, with things such as there was no finding of egregious breach. There was no breach admitted at all. We were still facing, in the Supreme Court of Canada, Ontario's argument that there was unfettered discretion. So I'm going to get into the differences between 2023 and 2025 later. But the proper question to ask is, if you really want to do a comparison, is if the Hurons would have been here today with us arguing about the quantification for the Hurons, what would be fair for them? Then you could compare apples to apples. But comparing a $10 billion settlement that the court has no way of gauging whether it's what it means is it's just irrelevant to what's fair and just for the RST, for the Robinson Superior First Nations.
When you say we don't know what it means, do you say we don't know what it stands for? We don't know what it measured.
We don't know what it stands for. We don't know what it measures. We don't know whether what litigation risks it entailed. I'm going to get into a little bit more detail when I deal with this topic in detail. But for now, the point is, it doesn't tell you anything about what's fair for the Robinson Superior Anishinaabe. It just tells you that there was a settlement for an X amount. If they had settled for $80 billion, it would be irrelevant. If they had settled,
it would be irrelevant to
determining,
RST or to the Crowns.
oh, it would be irrelevant to the RST. And it should be irrelevant to the Crowns in deciding what's fair for RST, right? We don't know what went into the decision of $10 billion. We don't know what factors the Crowns considered. The court cannot judge whether the 10 billion is any metric of value in these proceedings today without having complete details of the why 10 billion. Why not 80 billion? Why not 400 billion? Why? It's not presumptively honorable just because it's a settled amount. There could be any number of reasons why a settlement was achieved. So that concludes my introduction of the three biggest issues that make, quite frankly, all the difference. All the other issues are just noise, if you ask me. I want to turn to item 4, which is reconciliatory justice is not justice light. And that's the teachings of Takuhikan. I want to focus on what I see as an overarching error on the Crowns, and that is their deep misunderstanding of what reconciliatory justice requires of them. Ontario, at paragraph 38 to 44 of its decision letter, divorces reconciliatory justice from the need to identify what the annuities might have been and what was lost by the Anishinaabe. Ontario, in effect, converts reconciliatory justice into justice light. But that is not what reconciliatory justice is about. Canada, in its reasons, as far as I can understand, does not really explain what reconciliatory justice means to them, other than focusing on the repair of the relationship. In their factum, however, Canada at paragraph 54 says that reconciliatory justice is about compensating for past harms, but above all, to restore and improve the relationship. Fair enough. But in their implementation, they fail to implement that ideal. I want to turn to Takuhikan. Takuhikan is found at...
Could you spell that for the reporter, please?
I probably could if I'm looking at the piece of paper, which I am. Takuhikan, Takuhikan. It is a 2024 Supreme Court of Canada case, and it came out obviously on November 24th, which is after the decision in Restuel. But it's a very, very important case for this stage 3 review, Because for the first time, the Supreme Court of Canada has developed guideposts on how to deal with breaches of the honor of the crown and what reconciliatory justice means. And I want to take some time to go through this before the break. And I start about what reconciliatory justice means. And when you look at what the Supreme Court of Canada says it means, and when you compare it to how the crowns in this in this court process have treated it, the two are different. So let's start at paragraph 18 of Takuhikan, which you will find at page 40 of my compendium. Now, you will find specific tab 6, yes, thank you. You will find that in this particular case, because I thought it was so important, I've kind of highlighted in bold these sections I'm going to be reading from, because I don't think you're going to find the crowns referring to these sections, but I think it's important that we make sure that I make sure that the court appreciates what reconciliatory justice is about, according to the Supreme Court of Canada. So at paragraph 18, middle of the page, after saying that, I'll read the whole section, or the whole paragraph. However, given the distinct public law basis for Quebec's liability, a remedy meant to address the breach of the Crown's obligation to carry out its agreements in an honorable manner rests on a basis other than corrective justice. Now, I'm going to pause there because that's the section that I think the Crowns will focus in on, saying, well, it's not about corrective justice. It's not about paying for losses. It's something more holistic, more touchy-feely. But that's not a fair consideration of what reconciliatory justice is about. The court does go on and says, rooted in what may be described as reconciliatory justice, this remedy is not intended to compensate the individual claimant only for harm suffered as a result of past wrong. Then he goes on, the court goes on to say, it serves here, above all, to restore and improve the relationship between the Crown and Indigenous peoples in order to support reconciliation, a process that not only takes the past into account, but continues beyond formal claims resolution. And then they say, and again, the next highlighted portion, they note the importance of being creative within a principled legal framework, referring to none other than this case at paragraph 277. At paragraph 148, I want to jump to. The Supreme Court of Canada says in the middle of the page, when it's talking about, well, I'm going to read the whole thing. The underlying purpose of the principle of the honor of the Crown is to facilitate the reconciliation of the Crown's interests and those of Indigenous peoples, including by promoting negotiation and the just settlement of Indigenous claims. This purpose transcends the corrective justice at the heart of private law to make room for repairing and maintaining the special relationship. So it's not excluding corrective justice, it's transcending corrective justice. And I'm going to pause for a moment because let's not forget what actually happened in Takuhikan was that the First Nation had a non-treaty agreement, just a policing agreement with the Crowns. And it said in the policing agreement, this is all we Crowns are responsible for, and we don't have to pay any more than that. And in order to deliver Aboriginal-centric policing, there was deficits incurred by the First Nation. And the First Nation lost the opportunity. They said, let us negotiate with Quebec. Let us negotiate a better deal. And Quebec said, no, we don't have to negotiate. And even though the agreements were not treaty agreements, the honor of the Crown was still said to apply. And the result was that even though the First Nation was not able to prove under a private law corrective justice lens what it lost, it actually was paid. The Supreme Court of Canada said, you're going to get not just the damages you claim, but you're going to not have to return the money that Quebec contributed on top of that, because it transcends, it's above, it's not simply about damages. Paragraph 152. Now, when the Supreme Court of Canada then says public law rules, because we're in the realm of public law with the honor of the Crown, public law rules can thus derogate from the general civil liability regime, for example, by creating a form of immunity in favor of the state. Now, there's no evidence and no law that there has been a derogation of reconciliatory justice. The Supreme Court of Canada says the exact opposite. They then say, and this is the highlighted portion, these rules, and those are the public law rules, can also change the nature of the state's private law obligations or even intensify them. And that's exactly what they end up concluding reconciliatory justice does. It intensifies the private law obligation. It doesn't supplant it and make private law obligations irrelevant or obligations in the nature of private law, as a treaty might sometimes be considered. 153. I therefore agree with BJA's emphasis of the fact that Article 1376 of the Quebec Code is a provision that makes Quebec subject to private law obligations without, however, releasing it from its public law obligations. They have both. So both private and public law aspects. 154. In sum, under Article 1376 of the Code, the principle of the honor of the Crown and the obligations that flow from it are part of the other rules of law relating to civil liability of the state. Now, this is in the civil law concept, but the point is, these obligations, that's the obligations required by the honor of the Crown, intensify the state's liability in circumstances where they apply. The same is true in the common law world. In the common law, what reconciliatory justice should be telling this court is that the Crown's obligations are intensified in this instance, not diminished. Not a matter of some holistic feel right amount that the Crowns pick out of the air that just happens to be proportional to a Huron settlement. No, there needs to be some principled approach. And that principled approach is not followed by the Crowns. Turning again, paragraph 188. Supreme Court of Canada says the higher standard of conduct to which the Crown is subject creates obligations that are superimposed on contractual obligations. Well, that's again more, not less. The content of the contract is determined by its provisions and by obligations attaching to it under the provisions of the code, where the principle of the honor of Crown applies not only is the content of the contract interpreted generously, referring to Badger, which is a treaty case, but an additional public law obligation is superimposed on the contractual obligations, namely the Crown's obligation to act with honor and integrity in performing the contract.
Do you say there are any obligations superimposed on the obligations flowing from the treaty, or that the treaty is?
Yes, I do. And in a nutshell, and we're going to get to that, but it's not just about, and I think both Crowns have actually recognized this. Both Crowns recognize that it's not just about figuring out what the treaty annuity would have been. It's not just about financial recompense. It's about recognizing the damage we created to the relationship, the emotional harm that we caused to the relationship, how we caused suffering to 175 years of Anishinaabe peoples. It's about going above and beyond simply the dollar amount and recognizing that my clients, indeed all the Robin Superior nations, whether contingent beneficiaries or direct beneficiaries, all 12 First Nations, they were sentenced to a lifetime of 7 generations of poverty. That fact alone, poverty that didn't need to happen, that shouldn't have happened, that is such a disgrace that it needs to be remedied, remedied and recognized. In order to repair the relationship, you can't simply have a dollar amount to give restitutio in integrum, to just give back the contractual right or the treaty dollar amount. That's the minimum. But on top of that, there's the superimposed requirement to ask, what additional compensation is needed here to ensure, to further the path to reconciliation? What additional compensation is needed to effect deterrence and vindication in the constitutional sense? What additional amounts should be superimposed on the dollar amount to address those difficult to quantify losses, those intangible losses, the emotional harm, and the damage to the relationship that needs to be repaired? These are not quantifiable in a very easy way. Sometimes in malicious prosecution cases, harms to and stress and difficulties are dealt with as general damages, and we'll get to that. But it's something. At paragraph 188 at the end, the court notes that the honor of the Crown imposes this additional obligation only on the Crown, not on the Indigenous group that is the party to the contract. So it's the Crown's obligation to go above and beyond. Paragraph 190, interestingly, middle of the page, and this paragraph goes to the one of the problems with the engagement process. Supreme Court of Canada in Tacohican at paragraph 190 says, and I'm just referring to the bolded part, the Crown must come to the negotiating table with an open mind and with the goal of engaging in genuine negotiations with a view to entering into an agreement. The Crown should not enter into negotiations without intending to keep its promises, nor should it attempt to coerce or unilaterally impose an outcome. Now, I'm going to suggest to you later on that the Crowns, I'll suggest it now and I'll get to it later. The Crowns didn't come to the engagement process with a view to, with the open mind and a goal of engaging in negotiations with a view to entering into an agreement. They eschewed entering into an agreement. They treated it as a fact-finding mission like Vidal and Anderson had in 1849. We're here to listen. We wanted to enter into an agreement. The First Nations wanted to put some flesh to the bones of the relationship, to build the relationship, to build concrete what the relationship should be. Instead, Canada proceeded, I say, pretty much unilaterally, and we are left with an imposed outcome. That's wrong. Paragraph 191, highlighted part.
You say Canada or the Crowns?
The Crowns. Sorry. Thank you. The Crowns. Your question actually reminds me of a problem in this case, is that there really is only one treaty, and we're going to see that it's problematic to have two different approaches to how a treaty is to be implemented. There needs to be an understanding of what's right, of how to implement the treaty, and it's going to be difficult as we move forward if there can be two different views of what the honor of the Crown requires.
Well, I would like to hear your view on how that responds to the direction from the Supreme Court of Canada.
Yeah, I will get to that. Did you want my?
No.
No.
When you get there.
Okay, Ms. Lewis is making a note of that so that I will not forget, and I will address it directly later on in my presentation. Continuing on with Tacohican. Paragraph 191. What is involved in such a process, and that's the negotiation process, is a standard of conduct higher than one would adopt in a private law context, and must act in a way so as to maximize the chance of success. And I don't believe that if you look at the engagement process, that process stood a chance of success because the Crowns didn't give it the opportunity to mature in the way with an acceptance of ideas. There was not a willingness to entertain agreements. Paragraph 203 of Tacohican. Here we get to what the court's role in reconciliatory justice is about. As the public law regime associated with the principle of the honor of the Crown, it is concerned instead with the long-term relationship between the Crown and Indigenous communities, citing Kent Roach and Slattery. Then the bolded portion, the court must order any measure that is necessary to restore the honor of the Crown and thereby foster the goal of reconciliation, referring, of course, to Ristool at paragraph 277. This regime is much more flexible than the civil law courts this regime is much more flexible than that of the civil law. I would add that it would make sense that they would say, or the common law. And then they say courts can and must be creative in finding a remedy that advances reconciliation. I would add that the high standard that applies to the honor of the Crown justifies, in part, the exercise of the court's discretion to grant a remedy they consider appropriate. That's the court considers appropriate. And the finishing words of paragraph 203, within the sphere of reconciliatory justice, flexibility, not rigidity, is the rule. And we're going to return to that concept when I speak to the appropriate remedy towards the end of my talk, because a lot of what happened to the Anishinaabe is not easily quantifiable, but the court should not be put off or put aside or rendered unable to deal with that. If the court grasps the idea that the court can be creative. At paragraph 210, lest there be any doubt about what the honor of the crown requires and what reconciliatory justice requires, in Taku Hicken at 210, Supreme Court of Canada says a breach of the obligations flowing from the honor of the crown make available the full range of remedies, including damages and other coercive relief to remedy the breach. Again, quoting right from Restuo at paragraph 276. Finally, 224. Supreme Court of Canada in Taku Hicken says, the correct amount to be awarded as damages for a breach of an obligation flowing from the honor of the crown is highly contextual. Now, in this case, in the Taku Hicken case, the Supreme Court of Canada said, look, the First Nation has been wanting damages all along. So we should actually listen to what the First Nation's perspective is on this, and we should give them damages. But then the correct amount is a highly contextual issue. And in this case, this is the court talking, I am of the view that the amount determined by the Court of Appeal should be upheld, given the particular circumstances of the case, having regard to the purpose of the damages, which serve not only to compensate for past injury, but also to restore the honor of the crown. Again, it's cumulative. It's not that you can simply ignore the damages. Finally, I want to ask the court as we go along in the discussion to keep in mind the commented paragraph 225, where the Supreme Court of Canada says, as a result of Quebec's conduct, the respondent was deprived of the opportunity to negotiate more favorable funding terms. And the court says it's not possible to determine the position the respondent would be in today, but for the Crown's dishonorable conduct. However, since it is the Crown's dishonorable conduct itself that makes this impossible, Taku Hicken should not be penalized. And I am going to ask this court to take the same view of when it comes to quantifying the NCRRs and the indirect capture above NCRRs. You might remember that the reason why we don't have exacting data that would have made a court case much shorter was because the Crown chose not to keep track of data. And I remind the court that under any interpretation that any Crown in this case was ever advancing, even unfettered discretion, they had the obligation from 1850 onwards to keep track of revenues and expenses from within the treaty territory so as to know whether they wanted to exercise their discretion or whether it would ever be time to. And for that uncertainty to now be visited upon the victim is wrong. And the Supreme Court of Canada says that the victim should not be punished for by the consequences of the breach. I see we are a little past 12:30. I am finished my section on Taku Hicken. And I would suggest that we would break to whatever time, say 2 o'clock or 2:15, whatever the court would like.
How are you for your day, your plan for your day?
Well, for my day, I'm certainly going to go into tomorrow at this rate. May very well go into Wednesday as well.
But for your timetable, how are you?
For my
Are
timetable,
you meeting your,
the answer is yes, I am meeting, there's no reason to come back early if that's the question.
thank you. All right, let's do that.
So we would come back then when?
2?
2? Yes.
I hope that suits everyone, that you can find sustenance between now and 2. Okay, let's do that. Thank you.
The score is stood down until 2 p.m.